indication
Give us a survey.
Yes.
which each matter relates to.
So
How many
all
matters are
these,
there?
according to me, all these matters relate to the fact as to whether a person who has a B.ed degree is eligible for
All
appointment.
come from Rajasthan or?
44, all the matters are from Rajasthan judgment. All SLPs challenging the Rajasthan judgment. There is one writ petition also filed by the Rajasthan people because what is this?
Which one is that?
That is
And one from West.
Who is the junior most member of the bar in this matter? Yes, you are there. Okay, you are there. Kindly make us, who is the junior most member? Kindly give us a list. Madam, you're,
It's my colleague, madam, who is assisting me.
okay, you give us a list of individual matters and who is the petitioner, the judgment appealed against, and what has been held in the judgment. Okay.
in item 44, my lord. All the SLPs are against the same judgment, common judgment.
Dated 25th November 21. Rajasthan judgment takes a view that NCPE has not taken an independent view and has only acted on government directive, and therefore the Rajasthan High Court comes
Where is the power of government under NCT?
29.
Section 29.
I have reproduced it. If your lordship has it from my paper book, it is there.
Let's see the act. Direction matters.
Kindly check it. Yeah. 29.
No, you have to National Capital Territory.
No,
National
National
Council
Council
of
for
Teacher
Teacher Education.
Okay.
No, but in this, the council has to give direction.
It says the council shall, in the discharge of its functions and duties under this act, be bound by such directions on question of policy as the central government may give to it in writing from time to time. So the council shall be bound by such directions on questions of policy as the central government may give from time to time. Now, in very simply put the position that the right from 2010 onwards up to 2012, B.ed with an additional course was eligible for appointment.
That was under 23 subsection 2.
Well,
Or even if it is not, it was for a limited period. It was
correct. Up
relaxed
to 1st January 2012.
because these candidates were not available.
So therefore, that was the position. Let us take it that that was the reason for the position. The government then is confronted with a position where these Kendriya Vidyalayas, it starts with them. There is no doubt about it. Kendriya Vidyalayas come and say, sir, we are not getting enough people. Our posts are going a begging. And people with B.ed are available, they are good enough. We have been taking.
How is Kendriya Vidyalaya concerned with it?
No, it's not.
Because it says state.
No, it starts with that. The matter is examined on that request. Then the
Examined by whom?
the ministry, HRD ministry, the Human Resource Development Ministry, and by no less than the Honorable Minister himself. The chairman of NCT is there. The secretary of NCT is there. The minutes of that meeting are on the record. They find that in all states this is happening. And therefore a conclusion in that thinking comes about that there is a shortage. We must make them eligible.
Where is the direction?
I'll take that. If your lordship immediately wants the judgment reproduces it, kindly have my paper book and I'll show to your lordships.
Yours is 44.
Yes, 44.6.
Mukesh Kumar, SLP 20.
So that meeting, I'll take your lordship straight away to that meeting first.
Take us to that, whatever the
Yes, 28th May 18.
no, page number and
The page is 145.
No, internal page.
Internal page of the judgment. It is para 20 of the judgment. It is internal page 145 or 166 of the judgment because parties are many.
Paragraph.
Para 20 of the judgment.
Yes, para 20.
Yes.
So what is it?
Now, kindly have, I'll read the whole of para 20 to your lordship, so that just your lordship has the continuity. Shri Rastogi, learned, I'm sorry, my lord, is page 145.
Page
145, para 20. Internal paging of the judgment. It's the internal and other is the same. Para 20. I'll just read these one or two paras because this is really the crux of the whole thing. Shri R.D. Rastogi, learned additional Solicitor General appearing for the NCTE, has placed before us further correspondence which took place between NCTE and MHRD in this regard. These documents are taken on record. Perusal of these documents would show that after the minister put his remarks on 11th April 2018, MHRD wrote to NCTE pointing out that the minister has directed the NCTE to amend the qualification and make B.ed also an eligibility for teaching primary level, with a proviso of passing the module within 2 years of joining the service. We also note that in a meeting held on 28th May 2018, the officials of MHRD and the minister had discussed and deliberated the issues and decided to recognize B.ed degree course as an additional eligibility criteria for appointment to the post of primary school teachers in classes 1 to 5. The relevant portion of the minutes of this meeting read as under. File was called for. Kendriya Vidyalaya Sangathan, by letter dated 18th May 2016, requested the National, please score out bank, requested the National Council for Teacher Education to allow KVS to recruit primary teachers with higher qualification than prescribed by National Council for Teacher Education, that is graduation with 50% marks and B.ed. So this was the Kendriya Vidyalay's request. The matter was considered in this ministry and Human Resources Minister has approved the proposal of KVS to recruit primary school teacher with higher qualification, that is BA, BSc, B.ed plus TET. Further, Human Resource Minister has also directed that NCTE may amend the qualification and make BA, BSc, B.ed also eligible for teaching at primary level with provision of completing pedagogical modules in 2 years of joining service. These directions were conveyed on 12th April 18. However, action is still pending at their part. I pause here for 1 second. So 12th April, this direction was issued. Now it is considered further. Now come to para 3. Now we come back to 28th May. Matter was again discussed and deliberated in detail in the meeting held today, that is 28th May 18, chaired by HRM, that is the Human Resource Minister, and attended by, this is important, Special Secretary of the HRM Ministry, Chairperson of NCTE, Member Secretary NCTE, Joint Secretary Secondary Education, and KVS Commissioner. KVS Commissioner raised the issue of insufficient number of candidates applying for the post of primary teacher and candidates applying from few states rather than across the country. It was informed by Member Secretary MCTE that approximately 7.5 lakh seats are available for B.ed across the country, out of which 50% seats are filled. However, as TET pass D.ed candidates would be much less than the result of as a result of TET varies from 6 to 16%. This makes the availability of eligible D.ed candidates much less than desired. HRM also pointed out the need for better equipped teachers to ensure quality education in schools. Recruitment of teachers with higher qualification will ultimately be beneficial and interest of the students. In addition to the above, NCTE will roll out 4-year B.ed integrated course from next academic year. Therefore, the prevalent DLE education, B.ed, etc., will phase out in time-bound manner Further, similar kind of request has also been received from the state of Uttarakhand. In view of the discussion, HRM directed NCT to change its regulations. Directions are to be given under Section 29 of the NCTE Act. Section 29 of the NCTE Act is as follows. The Council shall, in discharge of its functions and duties under this Act, be bound by such directions on questions of policy as the state government may give in writing from time to time. Decision of the central government is as to whether a question is one of policy or not shall be final. We may request NCTE to submit a draft notification to amend the regulation at the earliest. Draft letter is attached for approval. Please, once the draft notification is received, same will be sent to the legislative department for vetting and approval. It's a conscious decision. It starts with KVK.
So you mean to say the power to pass such an order comes under the NCTA?
Correct. High Court.
And
has,
what about this act, right to education?
Well, this is also there, no doubt about it.
No, but this is an act which is focused for primary education,
Well,
elementary education.
Your Lordship is right.
And this is for general education. And special will override the general.
In fact,
In this, the power is only given to NCTE.
correct. NCT is the competent authority, but the power to prescribe qualifications is in 12A of the NCTE Act, which is introduced by a specific amendment in 2012. So qualifications are to be prescribed under the NCTE Act. Under the RTE Act, NCT is the authority competent. Please have section 12A.
A.
Yes, which is introduced by amendment. All right. 12A is added by amendment in 2012. The National Council, Your Lordship got 12A. The power of the Council to determine minimum standards of education of school teachers. For the purpose of maintaining standard of education in school, the Council may by regulations determine the qualifications of persons for being recruited as teachers in any pre-primary, primary, upper primary, secondary, senior secondary.
No, fine. So the power has been given NCTE.
Yes.
What is already there with the NCTE under 23(1).
Yes.
This further fortifies it that NCTE can do it by means of a regulation. No foreign on that.
So the same act contains, we cannot wish away 29. 29 is a very specific, what is it? In discharge of its functions and duties.
That is the question.
It is a function and duty of the Council to lay down qualifications. And on that, ultimately, the question is, if vacancies are more, the government is confronted with the situation. And here in Rajasthan, it is found, and in this process of selection, that there are more people available without B.ed. That may be so. That's a one-off. But across the country,
two apparent flaws in this proposition. One is, you are presuming that B.ed is a higher qualification than the diploma or whatever, which may not be correct. Second, this qualification of B.ed is effectively relaxing the qualification, which it can do under 23(2). That's the problem.
it's laying down an additional qualification. If there is no relaxation in the other.
No, additional would be you have a diploma plus you have B.ed,
it is laying down an additional set of people who are also qualified to teach. And it's nothing new. It starts from 2010 itself.
2010, there was an emergency situation. This act had just come up, so for 2 years it was done. See, the thing is that a diploma elementary is also 1 year or 2 years. Those persons are specially trained how to teach primary school students.
Yes.
For example, if you are an automobile engineer, see, an aeronautic engineer may be higher, but can he be engaged as an automobile engineer? You say aeronautic is much higher. It's different.
Correct.
Your qualification is not higher, but it's different.
But my submission is that actually what your Lordship is saying really is the work of experts. Now the Ministry of HRD, and who is their special secretary of the ministry, chairperson of NCT, member secretary, NCT, joint secretary, they are all present in the meeting when the decision is taken. These are the experts in the field. Now, I cannot say what your lordship is saying. Yes, it is a view possible, but these are all experts who have taken the view.
That aspect has also been considered by the learned judges of the Rajasthan High Court. Towards the end of the judgment, they have noted this fact. But then they have said that they don't even have power.
So
they are not experts.
So therefore, the first question is, the judgment of the Rajasthan High Court primarily goes on the point that there is no power under 23 to issue such a direction. My grievance with that judgment is, you have not even seen 29. All that 29 is mentioned. I'll show your lordship where it is mentioned and how it is mentioned. If your lordship will have page 153, last line.
Paragraph, if you can tell us.
Paragraph is, my lord, 29. Para 29, last line of that para, on the end of the page. The whole judgment is on 23 of the RT.
Somewhere it says.
I'm reading it. Para 29, last line. These 4-5 lines, that's all. When the central government note shows it is not even going under 23, it is going under 29.
No, but the notification says 23(1).
Now that I am going to say.
We are not on that.
Yes.
If you have powers, even
correct.
If it is not
mentioned. Wrong mentioning is, that is your lordship have settled right from the constitution.
FC and all that.
Yes. So just see 153 last line.
We'll come back.
Come back at 2.
All right.
Continue.
Devote rest of the day.
Yes. No.
But that's the difficulty with you.
I understand. I'll try to meet it and make it good. Ultimately, all right, when your lordship comes back. Yeah. You take it. Could your lordship kindly have para 16 of the judgment, just to give your lordships the background as to what all happened before the directive was issued. One, I have read that meeting of 28th May, but it all starts a little earlier and all that is discussed so that your lordship has the complete picture.
Just 1 second.
Opponents of this notification, particularly in the case of Mukesh Kumar Royal and others. So, because in Rajasthan there were 2 sets of petitions. The notification came making B.ed eligible. So, some persons who had the other qualification challenged that notification saying B.ed can't be made eligible. But in spite of that notification, the Rajasthan government advertisement of the post did not include B.ed as an eligible qualification.
Which was wrong, which was obviously wrong.
So, second set of petitions was challenging that advertisement saying it should be included. So, the petitions filed by the opponents of the notification stand allowed and the other petitions naturally as a consequence stand dismissed. So, that is the background in which para 16 has been worded.
As long as the law is there, it has to be there.
Correct.
Unless it's
correct. But in any case, that is how it says petitioners who are opponents, just to put your lordships in the picture. Petitioners who are opponents of this notification, that is that 28th June.
Advertisement notification.
No, this is that 28th June NCT notification.
Which has been
struck down.
Let's put it like this. Between diploma qualified and B.ed qualified.
Yes.
So these perhaps
are the diploma people.
Are the diploma.
Correct.
So it's diploma versus B.ed.
Yeah. who are opponents of this notification, particularly in the case of Mukesh Kumar Royal and others, sought information from the NCT and Ministry of Human Resource Development under the Right to Information Act as to the manner in which the decision to make amendment in the eligibility criteria was arrived at by NCT. Through this process, they have brought on record certain documents and information which need to be noted. It appears that on 30th May 2018, Ministry of HRD had written to NCT requiring the NCT to amend the eligibility criteria for primary school teachers in classes 1 to 5 so as to include any person who has acquired B.ed from a recognized institution, provided the person so appointed shall compulsorily undergo a 6-month bridge course which may be recognized by NCT, and such course will have to be completed within 2 years of appointment. I pause here for 1 second because something fell from my Lord Justice Dhulia, my Lord, which I want to clarify. Your Lordship said 23.2, it's relaxation. Argument from our side is going to be, it's not a relaxation under 23.2. It's an addition of a qualification under 23.1. Under 23.1, NCT is empowered to prescribe qualifications. And then under 2, it can relax them for some limited period of time. So here actually it's 23.1 power. Nothing hinges on that.
That argument, additional qualification you're saying?
No, as a qualification, as you, for example, for a particular post, you can have MBA, you can have postgraduate diploma in business management, you can have other such things. So here, apart from diploma, the government feels B.ed with bridge course should be a qualification under 23.1. It's not 23.2 relaxation which is being given.
No, you're saying additional qualification.
No, it's a qualification. I mean, additional means apart from the other qualifications provided in the note.
Then it is not additional. That is it. Then it is in the alternate.
Alternate. I stand corrected. I should have used the word an alternate qualification. Your Lordship is right. So that's ultimately, my Lord, basically your Lordships, if your Lordship finds government could not have directed, end of the matter. If your Lordship finds that no, the direction is possible under 29, then we succeed. I mean, that's the way I look at it.
Yes, that's the way.
I'll just continuing reading. Through this process, they have brought on record certain documents and information which need to be noted. It appears that on 30th May 18, the Ministry of HRD had written to NCTE requiring the NCTE to amend the eligibility criteria for primary school teachers in classes 1 to 5 so as to include any person who has acquired qualification of B.ed from a recognized institute, provided the person so appointed shall compulsorily undergo a 6-month bridge course which may be recognized by NCTE. Such course will have to be completed within 2 years of appointment. This communication is also being challenged. It will be useful to take notice of this communication. Now, this is the letter of 30th May. It follows that 28th May meeting, which I read earlier. So, I'll read this letter quickly. Kindly refer to letter of even number dated 12th April regarding request of Kendriya Vidyalaya Sangathan for recruiting primary teachers with higher qualification of BA, BSc, B.ed plus TET pass and letter number so and so received from NCT regarding the same. The above request has been considered in the ministry in order to safeguard the interest of students, ensure quality of education, and competent authority has decided to agree to the request of the Kendriya Vidyalaya to recruit primary teacher with higher qualification. The insufficient number of eligible D.ed candidates due to low pass percentage of TET examination has also become an issue for recruitment of primary teacher. Further, with the rollout of 4-year B.ed integrated course from next academic year, the existing B.ed course will be phased out. NCTE, by letter dated 23rd May 18, stated that the MHRD may consider implementing the directions in the detailed noting of the Honorable Minister of Human Resource Development, Government of India. Further, in view of the fact presented by the Commissioner KV, and since the NCTE did not have any objection to permit KV schools to recruit primary teacher with higher qualification, then there should be no objection to extending. That's right. There should be no objection to extending to other schools. Therefore, considering the power vested in MHRD under Section 29 of the NCTE Act, the regulation dated 25th August 10, determining of teacher to be appointed at primary level class 1 to 5, shall be amended to include that any person who has acquired the qualification of B.ed from any NCTE accredited school course will also be considered for appointment as a teacher in class 1 to 5, provided the person so appointed as a teacher shall mandatorily undergo a 6-month bridge course which is recognized by NCTE within 2 years of such appointment. It is therefore requested that draft notice qualification to amend the regulation may be submitted to the ministry. This may be treated as most urgent. Then, my lord, there is another meeting also which happened earlier, para 18. I'll read 17 also. The petitioner Mukesh Kumar has raised certain queries under RTI Act which were replied on 23rd March 21, in which it was provided that the bridge course had till then not been designed. However, a committee has been constituted to develop the norm and standard for 6 months bridge course, and report was awaited. Again, through means of RTI, petitioner sought further information regarding deliberations which took place before the impugned amendments were notified. Along with an order dated 28th October 20, the appellate authority under the RTI Act provided certain internal documents. One of them was the minutes of a meeting held on 9th April 18 of the officials of the MHRD, according to which the Kendriya Vidyalaya Sangathan had informed the ministry that up to the year 11-12, candidates having professional qualification of B.ed were also eligible for appointment. This is important. This is what I was saying. But that was still that period as an exception. There's no doubt. But they were eligible. It was noted that sufficient number of candidates having eligibility qualification were not available, which adversely affected the quality of selection of teachers. It was recorded that the competent authority had given conditional approval to the KVS to appoint primary teacher with higher qualification of BA, BSc, B.ed in case sufficient number of B.ed candidates were not available. It was therefore suggested it would not be appropriate to remove first condition, and KVS can decide as it is an autonomous body and competent to decide such matter. In short, the suggestion was not to include BA, BSc in the eligibility criteria at par with other educational qualification, but to allow KVS to expand the zone of consideration by including such qualification in case without inclusion, it was not possible to fill up posts. Significantly, these deliberations were with respect to KVS schools alone. When this note was placed before the minister, he placed detailed note expressing his opinion as under. There are DLED colleges in few states. Therefore, application for primary teachers come from limited states. B.ed is a postgraduate degree. They are ready to serve as primary teachers. So we get more equipped teachers.
Absolutely wrong.
There's
the problem. Absolutely. It's cut.
That best is cut. I mean, this is the way how it is in the judgment. It's a photostat. So we get more equipped teachers. So, I mean,
better equipped teachers.
Yes. The issue therefore are two. When more educated teachers are available, why students should not get benefit of better qualified teacher? Therefore, we must allow B.ed. Second issue is pedagogical for primary teacher, which is available in DLED and not in B.ed course.
Sorry.
There is, the only distinction is this pedagogical.
The entire pedagogical concepts are different.
So therefore they said, have a committee. Second issue, I'm reading. Second issue is pedagogical for primary teacher, which is available in DLED and not in B.ed course. The member has been found by teaching one specific module through the module. It should be the module has been founded. The module has been founded by teaching one specific module through Swayam and contact program also. Thus, it is very clear that students have the right to have better teachers. B.ed are more equipped as it is graduate, while DLED is +2, 12 plus. Final decision would be DLED would continue to be eligible to apply for primary post, Additionally, B.ed will also be eligible. When D.ed is selected, they can start teaching after formalities. When B.ed is selected, they will start teaching, but we will have to complete pedagogical module in 2 years. Thus,
So have you prepared this module?
this is para 17. Committee has been constituted to develop the norms, but in the meantime, this got quashed. So therefore, the committee could not develop the norms.
Suppose I am B.ed, I get a job as a primary school teacher, and within 2 years
I clear the course.
So this course is also for any duration of this?
6 months. 6 months. It's in para 17.
So
to develop norms and standard for 6 months.
See the multiplicity of problem. For 6 months, I'll have to leave the school.
For therefore,
6 months,
we may not draw salary or whatever. I don't know how it will work out.
Salary. We are only thinking of salary. For 6 months, what about the students there?
The program which is supposed
it's better, my lord, that they get the teacher after 6 months than not get them in their whole lifetime. It is better that these students get a teacher after 6 months. Today, the position is posts are vacant and going a begging. That is the statistics which have come on record as KVK and others. Only in Rajasthan for that process, they were excess. When this judgment came in 2020, your lordships have also approved this notification. There was no challenge on that, to that notification. There, your lordship was confronted with a problem. Thousands of posts in UP were going vacant because they didn't have the candidates. So they took B.ed people. And the courts.
But why this obsession with B.ed?
No, it's not a question of obsession. They are.
Looks like it.
Others are already there.
If the B.ed has to undergo a bridge course in any case,
correct.
Why not a simple graduate? Why are you insisting on B.ed?
Well, because it is BA and B.ed both. So you get a graduate with and you kindly see the addition. It is BA B.ed. It is both. Who has acquired Bachelor of
problem we are facing.
B.ed can only be after.
B.ed is for
Secondary
education.
Secondary education.
Secondary education, then primary education obviously has a special feature.
Correct.
For which
so
further training is necessary.
So my lord, ultimately,
so what is the necessity of B.ed in the first place?
My lord, there are two ways of looking at it. One is the way which set the government thinking in the first place. There were more vacancies. These B.ed people were not available. Vacancies were going a-begging. This set the government thinking. When this set the government thinking, there are no malafidis alleged against any person.
Nobody is saying malafide.
Correct. So when this set the government thinking, the MHRD minister at the highest level is calling meetings with his special secretary, with his joint secretary, with the chairman of NCTE, with the member secretary of NCTE, with the joint secretary secondary education, KVS commissioners, and coming to a conclusion this should be done. Now, therefore, if there was some malice attributed, your lordship could have suspected motives and then struck it down. If no, then that general principle that where experts have taken a view, nobody has an inherent right to say that such and such should not be eligible. So therefore, where I can understand if I was coming for inclusion, I am not coming for inclusion. I have been included. Now the question is, should a court under 226 strike down that inclusion? Because the court feels, according to us, it may not be good enough. There is no material. There is nothing. Court has not gone on the ground, it is not good enough. Court has purely gone on a legal issue that under 23 it could not have been.
Is there on that?
Correct. Now, that is the legal issue. Now, one other point. So, therefore, the first point that I am trying to make before your lordship is, it was not an overnight decision. 11th April, in any case, the consideration started. 11th April 2018, the consideration started. The matter was discussed. Initially, it was felt that it should be first DL, ED, in case of non-availability, B.ed. The minister then makes a note saying no. That note is at page 144 and end of para 18. He says both should be eligible. Then he calls another meeting on 28th of May. He calls everybody there. He is chairing the meeting, attended by special secretary, his own special secretary, the chairperson of NCTE, member secretary, etc. They all attend. There is a common decision taken that yes, this should be done. And thereafter, the letter of 30th May is written and the notification comes. Now, when in this situation, kindly see both the acts, that what is the setting of both, because your lordships had observed that in fact the RTE Act is really the correct one, and this NCT is for a different purpose.
Looks like it.
Just kindly see, let us see the objects and reasons of both the acts and how they have been brought
The
in.
level of education in mind, while
Correct. Level of education.
primary and secondary.
Correct. Right. Now, just kindly see the National Council for Teachers Education Act first, because I am relying on a provision in this act at 29, and both notifications are referring to 29.
This NCTE was in 1993 Act.
Correct.
Now, this was basically looking after secondary education and qualification earlier, because education, in any case, it's in the concurrent list now after 42nd level. And it was being looked after largely by the state. It's only when the Article 21A comes and this comes, and then now the whole purpose of this act is that elementary education has become free and compulsory.
Correct. That's the purpose.
That is the purpose. You recognize that purpose. And this act was challenged before this court, and Justice Kapadia's judgment is there.
Correct.
Upholding it, and we said that this education has not to be just a form, it has to be a meaningful education. Means quality education. Now, this is where the plot seems to have been lost. The focus is not on giving meaningful education, but focus is on giving employment.
So,
B.ed, we've got a lot of people qualified B.ed, give them employment. And then the focus goes away. Because if you read the teacher's eligibility test, and if you read the course and the curriculum of a diploma in elementary education, the pedagogy, they are talking about the pedagogy. These are the formative years. A child has come to the classroom for the first time in class 1. He is being how to handle him psychologically, how the teacher has to deal with him. Those are the important things here. Now, B.ed is not qualified for that. That is why it was not put as a qualification.
But all right. What is the basis for any person to come to the conclusion that B.ed is not qualified?
Because
there is no basis of that impression.
There is. Because under this 23(1), what will be the qualification will be given by a nodal agency. Notified
it is notified by NCT in 2010.
NCT is notified.
Correct.
In 2010, August, NCT comes with a quick notification of August 2010. When it says what is going to be the qualification is going to be intermediate or graduation, whatever, and a diploma in elementary education by whichever name it is called. Probably in UP it is called by a different name. In Punjab it's called by it's basic teaching certificate, LD, diploma, various. That is the qualification. Plus you have to qualify TET. B.ed was not a qualification, but it said that immediately we may not get these qualified teachers. So for 2 years, B.ed.
So B.ed was then ultimately.
Yes, because for a contingency. For a contingency.
So the way I would like to project it is B.ed was. Now, just let's see the setting under which the NCTE Act was enacted and the RTE Act. Just see the statement of objects and reasons. According to me, in the issue in hand from any book, just see the statement of objects and reason for the National Council for Teacher Education Act, right in the beginning, whichever book your Lordship is having. It's not in the paper book, unfortunately, but your Lordship will have to see. Because first, let's come to this conclusion, which is the relevant act which gets attracted. In my understanding, it is the 93 Act which will get attracted.
Is this? It includes education at all levels.
No, RTE Act was only to provide free and compulsory. I'll read it. Give me liberty of reading this statement of objects and reasons. Your Lordship has that. The National Council for Teacher Education was set up in 1973 by a government resolution as a national expert body to advise central and state government on all matters pertaining to teacher education. NCT's status and role have so far been purely advisory, and mainly due to this reason, it has had very little impact on the standards of teacher institutions in the country.
Teachers training institutions.
Teachers training institutions in the country, and on their unplanned growth. to maintain the standards of teacher education, the national policy on education states NCTE will be provided with necessary resources and capability to accredit institution of teacher education and provide guidance regarding curricula and education and provide guidance regarding curricula and methods.
Probably we have different books.
No, Lord, I think methods is the same.
Methods.
Yes. The program of action prepared for implementation of the NPE in 1986, realizing the inherent difficulties.
No, it's not matching actually.
It's not matching.
But anyway, we got your point that NCT is a specialized body.
Correct.
For that's what you want to say.
The bill, have your lordship got para 4? Para 3. The bill seeks to provide statutory powers to NCT.
We don't have it in.
No, I think you. आप इनको ये दे दीजिए. ये है आपके पास. ये एक कॉपी और है.
ठीक है ना?
You kindly see what we have.
Yes.
You can read from this.
All right, I'll read it from here.
Page 3. Page 2 of this. Objects of the Act.
This is some
Maybe
this is some note which is provided by somebody.
It's more than
not. Yeah, but this is not the statement
Yes,
of objects and reasons.
Yes.
The statement of objects and reasons actually is not here.
You are reading. You're right. We are being given them different.
Yes, statement of objects and reasons is not here. Have you got a book with the statement of objects? Huh? All right. So I will give your lordships my book, not because my friend has marked it and I have marked it less. So this, I'm sorry, I have one copy, but this is the statement of objects. Now, statement of objects and reasons. Shall I just quickly read it? No, it's just very short. The National Council for Teacher Education was set up in 1973 by a government resolution as a national expert body to advise central and state government on all matters pertaining to teacher education. NCT's status and role have so far been purely advisory, and mainly due to this reason, it has had very little impact on the standards of teacher training institutions in the country and on their unplanned growth. To maintain the standards of teacher education, the National Policy on Education stated that NCTE will be provided with necessary resources and capability of accrediting institutions of teacher education, providing guidance regarding curricula and methods. The program of action prepared for implementation of the national policy in 1986, realizing the inherent difficulties in the constitution of the NCTE to be able to guide the system of teacher education, envisaged conferring it with statutory status. The present bill seeks to provide statutory powers to the NCTE with the objective of determining, maintaining and coordinating of standards in teacher education, laying down norms and guidelines in various courses, promotion of innovation in this field, and establishment of a suitable system of continuing education of teachers. The bill seeks to empower the council to make qualitative improvement in the system of teacher education by phasing out substandard institutions and courses for teacher education. The NCT will also be empowered to grant recognition to institutions for teacher education, permission to recognize institutions for new course or training in teacher education. The bill also provides for delegation of various powers to regional committees and other committees for effective implementations of the functions. Then notes are there, etc. Then just have the short title of the bill at the top. An act to provide for establishment of National Council for Teacher Education with a view to achieving planned and coordinated development of teacher education system throughout the country and regulation and proper maintenance of norms and standards of teacher education, including qualifications of school teachers, is added in 2012 when 12A is added.
12A.
And after the RTE Act, my friend is right, and for matters connected therewith. Now, this is focusing on all this, on qualifications, etc. Now, see what the RTE Act is focusing on. Just kindly have the statement of objects and reasons of that. The RT Act is focusing on providing free and compulsory education to students.
That's true.
So qualifications.
Where do you have objects and reason of this?
Right, statement of objects right in the beginning of the book. Right in the beginning of the book.
Elementary education.
Page. I think. What the Your Lordship's book will have it.
Yes.
Your Lordship got it? Yes. Now, statement of objects and reasons. The crucial role of university elementary education for strengthening the social fabric of democracy through provision of equal opportunities to all has been accepted since inception of our republic. The directive principles of state policy enumerated in our constitution lays down that the state shall provide free and compulsory education to all children up to the age of 14 years. Over the years, there has been significant spatial and numerical expansion of elementary schools in the country. Yet the goal of universal elementary education continues to elude us. The number of children, particularly children from disadvantaged groups and weaker sections, who drop out of schools before completing elementary education remains very large. Moreover, the quality of learning achievement is not always satisfactory, even in the case of children who complete elementary education. Article 21A, as inserted by the Constitution, 86th Amendment Act 2002, provides for free and compulsory education of all children in the age group of 6 to 14 years as a fundamental right in such manner as the state may by law determine. Consequently, the Right to Free and Compulsory Education Bill 2008 is proposed to be enacted, which seeks to provide every child has a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school, which satisfies certain essential norms and standards. Compulsory education casts an obligation on the appropriate government to provide and ensure admission, attendance, and completion of elementary education. Free education means that no child other than a child who has been admitted by his or her parents to a school, which is not supported by the appropriate government, shall be liable to pay any kind of fee or charges or expenses which may prevent him or her from pursuing and completing elementary education. The duties and responsibilities of the appropriate government, local authority, parent, school, so and so. System for protection of right of children and centralized grievance redressal mechanism. The proposed legislation is anchored in the belief that values of equality, social justice and democracy, and creation of a just and humane society can be achieved only through provision of inclusive elementary education to all, provisions of free and compulsory education of satisfactory quality to children from disadvantaged and weaker sections is therefore not merely the responsibility of schools run or supported by appropriate government, also schools which are not dependent on government funds. It is therefore expedient to enact a suitable legislation as envisaged under Article 21A of the Constitution, and then the bill is enacted. And the objects is to provide free and compulsory education, because it's on the top of before the statement and objects. An act to provide for free and compulsory education to all children of the age of 6 to 14 years. Now, when your Lordship compares it with the NCTE Act's object, there the object is.
It doesn't make a
reference to qualifications, etc.
no.
There, now kindly.
For education in general.
Correct.
And this is education for a particular age group.
Correct. That NCTE said an act to provide for establishment of a National Council of Teacher Education with a view to achieve planned coordinated development of teacher education, regulation and maintenance of norms and standards in teacher education, including qualification of school teacher. So really my point before your Lordship is that provision of norms and standards in teacher education, including qualification, is actually more a focus of the 93 Act. The purpose and focus of the 2009 Act is to implement Article 21, what started from O.N.E. Jain, which said free and compulsory education to everybody up to the age of 14 years. Norms and standards required for appointment is more a focus of NCTE Act, is the submission. So basically, my lord, according to me, the case is, my case is in a very narrow compass. I say it's the National Council for Technical Education Act which provides, which is the relevant legislation which provides for what are the norms to be laid down. Section 29 is very clear on matters of policy directions can be. It is nobody's case. This is not a matter of policy because whether B.ed is eligible to be appointed or not is a policy. It's a national policy. And the decision has been taken at the highest level and in consultation with all authorities that this should be included. So therefore, I submit, my lord, that it's a well thought of, conscious decision taken by experts that this should be included, and therefore, since I'm not coming for inclusion, your lordship could have shut the door on me saying, sorry, in 226 we are not going to include or exclude you. But somebody is challenging my inclusion made by experts. There the yardstick is totally different. There your lordship will see, is there some malicious purpose? Number one, there is nobody's argument. Second, your lordship will see, and the High Court rightly goes to see, is there a power to do it? There I say the High Court has gone wrong. High Court has only considered 23. High Court has not considered 29 of the NCTE Act.
No, it has considered, not at the place that is there. It says 29 government can lay down a policy.
Correct.
Somewhere it says.
I'm reading it. In fact, I was going to read it and then.
But what it says goes on to say, it is not that policies cannot be challenged in a court. If it's a wrong policy and it goes against the Act.
29. So just kindly.
That's what it says somewhere in the judgment.
Yeah, yes, para 29. I'm going to bring your lordship to that. Kindly see para 29. Para 29 on page 153 of the judgment, last line.
Para 29.
Yes. Starts on the top of the page, third line, at 153.
Yes.
The last line on that page.
NCT Act है.
Para 29 deals with the argument of the Additional Solicitor General that I have exercised power under 23(1) and not 2. Anyway, I am not going on that for the time being. Last line. A reference of course was made. Your lordship got that last line on the page. Your lordship got it? All. A reference of course was made to section 29 of the NCTE Act for such purpose. So under subsection 1 of section 29, the NCTE shall, in discharge of its functions and duties under the Act, be bound by such directions on question of policy as the central government may give in writing to it from time to time. However, in our opinion, the central government cannot trace the source of power to give such directions to the NCTE in exercise of its power under subsection 1 of section 23 of the Act. The primary source of power of NCTE to frame regulation prescribing the minimum qualification for appointment of teachers is in subsection 1 of section 23. In exercise of such powers, NCTE is not to be guided or bound by any directive that the central government may issue. We do not find any such power retained by the central government under the RTE Act. In plain terms, therefore, the Ministry of HRD could not have mandated the NCTE to make the amendments in question. It is beyond dispute that amendment is not the original work of NCTE. In fact, the opinion of NCTE was that many B.ed may be recognized as an alternate qualification for KVKs, where adequate number of qualified candidates are in short supply. Overruling such opinion of NCTE, the Ministry of HRD mandated that B.ed may be recognized as additional qualification for all schools. This was clearly beyond the power of the central government. Then this is where they have dealt with it. Then it continues on in para 31. I can read 30 also. In fact, to continue, and let me read. The RTE Act was enacted to provide for free and compulsory education to all children of the age of 6 to 14 years. As noted as per subsection 1 of section 23, a person possessing such minimum qualification as laid down by academic authority, authorized by the central government by notification, shall be eligible for appointment as a teacher. The primary source of the authority of NCTE to lay down such qualifications is is subsection 1 of section 23 of the RTE Act. We are not oblivious to the fact that 12A was inserted in NCTE Act with effect from 1/6/12, which provides that purpose of maintaining standard of education in school. The NCTE may by regulation determine the qualification of persons for being recruited as teacher in various levels of schools and colleges. We may recall that the NCTE Act as originally enacted was to provide for establishment of National Council for Teacher Education with a view to achieving planned and coordinated development of teacher education and regulation and proper maintenance of norms and standards. Purpose of qualification of school teachers was inserted in the preamble only with effect from 1st June 12. Essentially, thus 12A of the Act is the echo of the primary source of power of NCTE, flowing from 23(1) of the RTE Act to lay down minimum qualifications. It is for this reason, in our opinion, the power of the central government to give directions to the NCTE under 29 cannot be utilized to require NCTE to frame regulations concerning eligibility of teachers. Even otherwise, we do not think that the powers of the central government under subsection 1 of 29 are wide enough to require NCTE to frame regulations of eligibility in a particular manner. As per section 1 of 29, NCTE shall in discharge of its functions and duties be bound by such directions on question of policy as the state government may give from time to time. Power of the central government to issue directions and its binding effect are confined to questions of policy. Legislature had advisedly limited the powers of the central government to issue directions only on questions of policy. They are not plenary or all-pervasive, but restriction to question of policy cannot be interpreted strictly. Therefore, has to be interpreted strictly. Legislature has constituted the NCTE with specific duty, function, and powers, which council consists of experts in the field, has also, while empowering the central government to give directions, advisedly restricted such powers on question of policy. Direction of central government cannot be for day-to-day functioning of the NCTE or other than policy. This is not day-to-day functioning.
What happens is, something which has not been touched in this judgment is what is the appropriate government would be. There are two kinds of schools. Element one is by central government and the other by state. Exactly. KVS, that initially when it comes from KVS, possibly in central school, if appropriate government, then central government can say that. But for the schools which are purely state schools.
So the power is only with the central government under 29. The power to give directions under section 29 of the NCTE Act is only with the central government.
It has to be.
There was this Bokshi, I think.
Exactly.
Come to Supreme Court.
Yes,
Is there a judgment?
judgment, your lordship, upholding the judgment of the High Court to the
Is
extent
it a written
unless-
judgment or a total dismissal?
In 2015, that matter came up for the SLP hearing when the Honorable Bench pleased to record that there has been subsequent developments because RT Acts and all had come, but not specifically mentioned RT Act has come, recorded subsequent developments, so disposed of it.
Education Act.
Yes,
There the government has some powers.
yes. Right to education.
Right to education. Has central government can direct NCTE to put this curriculum, that curriculum.
That is for regulations, I think. I'll just do that. One second. Where is 29 is at day 16. Curriculum and evaluation procedure. The curriculum and evaluation 29.
Yes.
Curriculum and evaluation procedure. The curriculum and evaluation procedure for elementary education shall be laid down by an academic authority to be specified by the appropriate government by notification. Now, this is NCTE now. The academic authority, by laying down the curriculum and evaluation procedure under subsection 1, shall take into consideration the following. conformity with the values enshrined in the Constitution, all-around development of child.
Oh, that is all right.
Yeah, those
But
are
appropriate government, you see what is the definition of section 2.
yes,
Government also has got a limited function here because you see,
yes.
it is in the concurrent list. So there is
That's what your lordships just observed. It is exactly in tune with that.
C21.
Correct.
Appropriate government means what?
In relation to a school established, owned or controlled by central government or administrator of union territory, having no legislature, central
Then
government,
it is the central government.
and other cases, state government.
So if it's a Rajasthan school, the government would be the Rajasthan government.
Correct. Under 29 of this act, your lordship is right. But under 29 of the other act, the direct council shall, in discharge of its function and duties, be bound by such directions on question of policy as the central government may give.
There is nothing by way of a reference also to this act.
Correct.
NCT.
So there are two sources of power. The question is, government is entitled to utilize.
In
The
the
question is again which government?
2009 Act, the sources of power are delineated.
And now kindly see the 73 Act.
93 Act,
93 Act.
it is central government.
Correct. Now the question is, if the central government.
Subsequent act, if there is delineated power, what would be the result?
My lord, in fact, to that I have one very simple answer, and that is, and then the legal issue. Simple answer is that the amendment came in 12, giving them power to lay down qualifications to the NCT. So since that specific power is given under the 93 Act in 2012, question of subsequent special act may not come in here. RT Act comes in 9. In 12, the government amends the 93 Act, gives power for this specific purpose to the NCT under that act, and therefore the power is exercised under that act.
No, but it could not have amended this act.
It could have if it wanted.
No, because this act says, it does not even speak about NCT.
Exactly. I'm grateful. That's my whole point. That is the point I'm trying to make. That this 93 Act has been the RTE Act has been brought in wrongly.
No, Article 20, because the one says that which will be the academic authority which will prescribe the qualification. It will be the academic authority notified by the central government.
I understand what is falling from your lordship. They could not have. If 2012 amendment could not have come in this act, that your lordship is right. That had to come in that act because that was the power being given to NCT.
Right.
So if the power is being given to NCT, it has to go in that parent act.
Yes.
They can't give. I mean, they should not have given it and correctly not given it here, and they've correctly given it there. But then that makes out my point. Is my submission. That makes out my point. That if the power is under the 93 Act, then please look at the power of the central government under that act. We should not look at the power under this act now. If the power to lay down qualifications is given under that act, then the power of the central government to regulate the conduct of NCT has to be looked at under that act. And there the power is very clear. And for the court to say it's not a matter of policy, has only to be noted to be rejected. I mean, of course, it's a matter of policy. Whether B.ed is eligible for being appointed as a teacher for primary education is a matter of policy. It's a national decision taken for the whole country. And a judgment is relied on which has absolutely no relevance to the facts of this case. Some service conditions to be framed by a particular body, by the port trust, and the government gave a direction.
Policy once translated into a statute, then it becomes subject of judicial review. If it
Correct.
Otherwise in conflict with some other statute.
Correct.
So that policy immunity doesn't operate in real terms. It's not an industrial policy of 1950.
No, that is right. I am not saying your lordship can't look into it. Of course, your lordship can look into it.
Bennett Coleman.
Yes. The High Court says it's not a question of policy. That's the point I'm trying to make. That the High Court holding not a question of policy in the facts of this case, it is very much part of the education policy. What is the qualification for a teacher of a primary school, whether B.ed is to be included or not, for a PAN effect is of course a policy of which the HRD has to look into, and therefore the HRD has rightly looked into it and said that, so here, my lord, I respectfully submit that the very same judgments which say that inclusion is not possible under 226 will come to my aid to say that once included, then evaluation is not possible. And there is no basis of, nobody has laid down a fundamental basis of why. And this pedagogical is not there, that they say do a bridge course. Now, therefore, my lord, in fact, the way I look at it, my argument is very simple and straightforward. My argument is, number one, it's a well thought of. It's not a decision which came as a flash in the pan. Topic was simmering. KVK was having problems. The matter was discussed on 11th April. 11th April, they said, so Uttarakhand also has come and told us we are not having teachers. Therefore, they said, have it pan-India and include them. Then comes the thinking which says, but make it first diploma. If not available, only then they should come in. The HRD minister says, no, I don't agree. They should be made eligible. Then he, however, calls the meeting on 28th of May. Everybody comes for that meeting. A decision is taken in that meeting that this should be included. And that decision leads to the 30th May letter. And I say the 30th May letter is fully supported by section 29. NCT accepts it and includes it. So therefore, there is no legal flaw, is the submission. This is my argument before your lordships in this case. Now, there are some other things to support it. I can make a short note and give it also. Thus, to support it also, I say, look, in any case from 10 to 12, it was included. Whether it was included because shortage or for whatever reason, it was good enough. People were being appointed from 10 to 12. And therefore, it's not something as if it's something which is really come out of the blue. These people were being appointed from 10 to 12. So in the face of this well thought out decision, my submission is, my lord, the High Court has completely erred in striking it out, relying only on section 23 and saying that no, 29 will not apply because it's not a policy decision is wrong, is not correct in my respectful submission. Now, there are some observations in that Ram Sharan Maurya's case, my lord. Your lordship may kindly see that. I must start by telling your lordships that there was no challenge to the notification.
No, you mean to say, if NCTA has set qualification as A, can a policy decision be taken under section 29 and say qualification can also be B?
I would respectfully submit, yes, it can be done, because this qualification B is not coming out of the blue for the first time. This qualification B, before the 2010 notification, was included for appointment. Under the 2010 notification, let us take it as an exception, it was included. So the long and short is, up to 2012, it was good enough. It is only in 12 that it was excluded.
Do you have that notification of August 2010?
Yes, it's there on the record.
The answer will be in that only.
All right, I'll read that.
Where is it? Which page is it?
Yes, that is at page 190.
You're reading what?
25th August 2010, SLP paper.
I'm on 44.
Yeah, 44.6.
44.6.
Is Mukesh Kumar versus State of Rajasthan. SLP 2061.
Where is the English version?
Yes, English version is, my lord, at page 194.
This notification was originally in English only.
Yes, it's both Hindi and English. The original gazette is in both.
In the
yes.
Page
194. I'll tell you.
Yes.
Then notification at 194 middle 23rd August in the exercise of powers conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act, and in pursuance of notification dated 31st March 10 issued by the Department of School Education and Literacy, Ministry of Human Resource Development, National Council for Teacher Education, hereby lays down the following minimum qualifications for a person to be eligible for appointment as a teacher. in class 1 to 8 in a school referred to in clause N of the Right to Free and Compulsory Education Act, then minimum qualification for classes 1 to 5 is senior secondary with 50% marks and 2-year diploma in elementary education. Then senior secondary, again with that 2-year diploma in elementary education, and senior secondary and 4-year bachelor of elementary education, or senior secondary or equivalent with at least 50% marks and 2-year diploma in education, specialist education. And apart from these 4 alternatives, you must also be a pass in the teacher eligibility test conducted by the appropriate government. Then para 2. Then comes for class 6 to 8, we are not concerned. Then comes diploma degree course in teacher education. For purpose of this notification, diploma degree in teacher education recognized by the NCT shall only be considered. Then comes serial number 3, training to be undergone. A person with BA, BSc with at least 50% marks and B.ed qualification shall also be eligible to be appointed for class 1 to 5 up to 1st January 12, provided he undergoes after appointment an NCTE recognized 6-month special program in elementary education. So this was also made. Now in this, if your lordship will see, it was only BA, BSc.
You're reading page, which page is this?
196 at the top.
Yes.
Training to be undergone. A person with BA, BSc with at least 50% marks and B.ed qualification shall also be eligible for appointment for classes 1 to 5 up to 1st January 12, provided he undergoes after appointment an NCTE recognized 6-month special degree program in elementary education.
No, there is a subsequent notification.
Subsequent is
no, not this one. Subsequent also was for similar, which says this problem has come from various states. Requisition has come that diploma qualified teachers are not available. Therefore, it was extended for another year. Something like that. And that was because
that happened. My friend tells me in Uttar Pradesh. Mr. Amit Pavan tells me that was in UP. No, the other notification is of the government of India, which said make BCom also eligible. That is page 200. The only change there is graduation with 50% and B.ed. So graduation means BCom also. So BCom also got included on the directions of the central government. Then comes this notification, impugned, that is 28th June 2018 at page 203, English at 204.
Why does it say National Council for Teachers Education notification?
Yes, it is their notification.
It is their notification.
Correct. And government wrote to NCTE to notify, and then NCTE notified. On 30th May is the government letter, and 28th June is their notification. That government letter is quoted in the judgment of the High Court. This is National Council for Teacher Education. That is why I am saying that NCTE ultimately accepted the direction. Now, in the exercise of powers conferred by subsection 1 of 23, that's important. It's not under the exception. It's under the main provision of prescription of qualification. So they have not made an exception. They have made it an alternate qualification.
Additional qualification.
In the exercise of powers conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act, and in pursuance of notification dated 31st March 10 issued by the government of...
So formally the notification has come under 23(1) only.
Correct. Correct.
that this is on direction of the government, therefore it's bad.
Correct. High Court says that 30th May letter saying do it.
Do it. So you have
And then they have done it. High Court says it could not have been done because High Court says 23(1) doesn't give you any such power of the RTE Act. NCT Act, they say 29 also doesn't give you power. In any case, this is not a matter of policy, and therefore you could not have done it. These are the two grounds. Therefore, I was saying that once it is done, therefore the High Court now can't sit over it because it's not a flash in the pan. Two things. It's a well thought of decision which was simmering for a period of time and ultimately culminated in that direction. May asking the NCT to do it is under 29. The decision of 28th of May refers to 29. The decision of 4th April also refers to 29, which is all reproduced by the High Court and made part of the record under the RTI.
The fair case would be that NCTA has not thought over it. NCTA has
Correct.
not applied its mind.
Correct.
Whatever has been said, included, they've done it.
So
it's bad.
So NCT. NCT is here. NCT is here to defend.
NCT has certain external dictator. that the scope of 23(1), the academic authority has to independently apply its mind and then devise whatever education is required. And for that expert purpose, the diktat of central government would not be necessary. And that would be not necessary. I mean, that would be external diktat kind of thing.
But Malad, how would this argument arise that they have not applied? The central government issues a direction to NCT. NCT could have responded saying, sorry, I don't think this is good enough. The NCT, no, Malad, when we are going into an academic issue, academically, it's not that it's.
No, it's not academic.
Yes.
On the face of it,
Now,
application of mind by NCT.
The NCT chairman and the member secretary and the joint secretary are there in the meeting of 28th of May, all three of them. And they provide the data. On that basis, the direction comes. And then the direction goes to NCT on 30th of May. This notification is on 28th of June, after almost a month. And NCT is here to defend its decision. What? So the NCT is here to defend its decision. NCT is standing by this notification.
NCT is with you.
Yes, NCT is not saying we were browbeaten by the government. NCT is, no, that they may say so anything.
They say so, then they'll.
So
You have said it.
So NCT says we are supporting this. This is a good notification. So where is the justification for a court to strike it down in such a situation? And Lord, it's not, we are not aliens in that sense of the term. We are people who were eligible up to 2010. We remained eligible up to 2012. From 14-15 itself, this problem arose. 16 KVK writes to the government saying that we are in difficulty, we don't have teachers. Uttarakhand writes we are in difficulty, we don't have teachers. 18, the meeting takes place, the decision is made and the notification comes. Now, the submission therefore is, once the experts have decided to include, how can the High Court therefore could not have quashed it saying it's not good enough? So High Court doesn't say that. Says no power. There I say this is not correct. With the utmost of respect, because 29 has not been appreciated in its correct spirit, in its correct perspective. 29 is the direct provision. It is under the correct act where qualification is laid down, and that gives a power to issue directly. Other part, not policy, I say, has only to be noted to be rejected. If this is not policy, there can never be a policy. This is a policy as to who is eligible for being recruited.
Who's for NCT?
I have
Rely on some
I
authority.
have just some judgments to show and then I'm done. This is all.
You can show it later. Judgment we can see later.
All right. All right.
But on what proposition?
But only Ram Sharan Maurya is the one. Others are high courts. They will not bind your lordship. Just see what Ram Sharan Maurya said.
What proposition you take?
In UP, what happened? That some Shiksha Mitras who were primary teachers appointed on a temporary basis, services were terminated. They wanted re-employment back.
No, you tell us just briefly.
Yes, very briefly.
No, what is the principle you want to?
The principle was, the issue arose whether B.ed people are to be considered for appointment as primary teachers or not. Relying on these notifications, your lordship's bench had said that yes, they are eligible, they are to be appointed. But I must say that there the vires of the notification was not under challenge.
This court judgment?
Yes.
So that was under a special contingency where lakhs of such teachers were on the road.
Correct. No, that was where they had applied. Let me just show your lordship what, it's just 2-3 short paras and then I'll be done. Sorry.
Totally different.
And that Allahabad High Court judgment.
This is Supreme Court arising out of the Allahabad High Court. Your lordship is right.
That was Justice Chandru's judgment.
No, Justice Lalit. This is Justice Lalit and Justice
Allahabad judgment.
That was Shiv Kumar Pathak. That was initial 2011 initial. That was a sensitive cell.
Because that is the judgment of Allahabad High Court. We have been following it all through.
Yes.
Correct.
That judgment.
That was wrong.
That was also.
It is page 12. Kindly see it at page 46, para 65. Para 64 onwards. Para
64.
64. We must now consider the issue of eligibility of B.ed candidate in the present selection. In TET examination held in March 2018, out of 3,68,000 qualified candidates, Shiksha Mitra were 40,000 only, meaning thereby that a large number of candidates other than Shiksha Mitra had been declared qualified. Paragraph 4.2 of the government order dated 1/12/18 referred to certain directives of NCT, which in turn had dealt with the eligibility of B.ed candidates. It was therefore quite apparent that in the ensuing selection process, considerable number of B.ed candidates would participate. In this background, the absence of any challenge to the entitlement of B.ed candidates to participate in the process and appear in the ATRE 19 is crucial. But we do not propose to rely only on this aspect and proceed to consider whether candidates holding B.ed degrees are entitled in law to be considered eligible in the present selection. The National Council for Teacher Education was enacted to provide, then the Act is referred to, then 67 earlier judgments are referred to, then para 70, power 12A is referred to, then your lordship may come to para 72. It is thus clear that for maintaining standards of education in school, NCT is now specifically empowered to determine the qualification of persons for being recruited as teachers, schools or colleges. In addition to regulating standards in teacher education system, NCT Act now deals with regulation and proper maintenance of norms and standards in respect of qualification of persons to be recruited. Having noted the change in the scope and ambit of Act, another development must be noticed. Right to children of free compulsory education. Then this Act is noted. 74, that 10 notification authorizing NCET is noted. Then para 75. Notification dated 28 June 18 issued by NCT was an exercise of power conferred by it upon virtue of notification of March 2010. In terms of the notification dated June 18, qualification of Bachelor of Education from any NCT recognized institution shall now be a valid qualification for appointment as teacher in classes 1 to 5, provided the person so appointed mandatorily undergoes 6 months bridge course within 2 years. Going by the parliamentary intent in empowering NCT under the provisions of the Act and specific authorization in favor of NCT notification dated so and so, authority of NCT is beyond doubt. Though there is no specific regulation as contemplated under 32 Red with 12, for the present purpose by virtue of specific authorization under the notification of 10, NCT was entitled to lay down that those holding qualification of Bachelor of Education are entitled to be appointed as teachers in 1 to 6. Such prescription would be binding. In this, it is for this reason that GO notifying so and so clearly stated candidate possessing qualification could participate. Then, my lord, the eligibility in law thus being beyond doubt. Next question is, etc., etc. So your lordships have given a finding that they are eligible, but there was no challenge to that notification. But anyway, this is also persuasive and binding.
This was not shown to the judges in Rajasthan.
No, it is. It was not. I think probably it is later. It doesn't appear it was shown. It was shown to some other high courts in the country who have followed it.
They just followed it because of this.
Rajasthan High Court judgment is of
25th November 2021. This is 13th November, so it may have been reserved.
no.
This is 18th November.
This is of 2020.
2021. No, I don't think it was shown there. All right.
We'll hear the counsel for LCP.
It's, I'm also appearing for the persons minutes who applied, who were disqualified by the notification of by the advertisement. I am appearing for the.
We can just hear the counsel for NCT for some time, then we.
Very well.
I would like to draw my lord's attention to where we draw the power, the NCT. That flow of power is very important to be considered. Lords, even particularly if we are talking about Rajasthan, when Rajasthan Panchayat empowers NCT, like look into the NCT's power. So I'll just show my lords how like section 23 of the RTE Act and section 35 of the RTE Act, that needs to be read harmoniously with section 29(1) of the NCT Act. As my learned friend submitted, section 29 is the power which we derive to come up with the qualification or the take the notifications or directions from the central government. And section 12 empowers us to specify the necessary qualifications. Well, section 23, if the section 29 has been read out to you, 23 has been read out to you. Now, I again emphasize on section 12A. 12A, powers of NCT to determine the standard of education for the school teachers. For that, and then the central government provides power to determine the minimum standards of the educations of the school teachers and appointment of teachers stemming from the requirement of section 23(1). So these are interconnected provisions, my lords. So they can't be read in isolation, which Rajasthan High Court has done so. So this has to be read in harmony with each other. Then it clearly gives in power and authority for even the central government's power is identified from there, and even the NCT's power to specify the qualification is derived from there. Let's coming to now last that section rule 263 of Rajasthan Panchayat Raj Rules 1996. That also says that the primary and upper primary school teachers education.
Why do you have to relate to Rajasthan Panchayat Act?
Even that says that the
even if it says, you show on your own strength.
Yes, my lord. Then I am talking
because the Panchayat is recognized here.
It is the
okay. Sorry.
Yes. So section 29 is the main section which has been laid out to you, my lord.
Well, you can show your Panchayat.
Yes. Panchayat, my lords, may have the paper book of 44.8. That page number 191, I have reproduced that.
We will only look at this particular paper book.
Okay. That has nobody else has reproduced this provision.
Which one is this?
44.8.
8.
44.8.
Yes.
That's a petition by NCT, my lords.
You have also challenged Rajasthan High Court judge.
Yes, my lords. Because we stand by our notification, my lords.
Where is the junior most member?
So, which page you want to take us?
Page 191, my lords.
You kindly give it to us tomorrow. Yes.
So that says that rule 266, academic qualification, recruit must process minimum qualification as under primary and upper primary school teachers. Qualification as laid down by the National Council for Teachers Education under the provision of subsection 1 of section 23 of the Right to Children to Free and Compulsory Education Act, and from time to time and must have passed the RTET and RTE. Qualification as laid down by the National Council for Teacher Education under the provisions of subsection 1 or subsection 23 of the Right of Children to Free Education, and from time to time for the teachers. That's the sum and substance, because even the Rajasthan Panchayat Act goes back to say that whatever the NCT prescribes the qualification, that has to be taken into consideration.
No, but why you have included here is that qualified teachers, that is teachers who have the qualification of the diploma, primary diploma, are in a shortfall.
Policy 59 is not Policy.
Is that the reason they're not available?
Is not policy.
No, in Rajasthan, that was not the issue.
Then
But in all other states, like my current friend who now,
you come to Rajasthan first.
please, ma'am.
In Rajasthan, is that a problem?
That's not the problem.
Suppose if there are 100 seats, right? And there are 200 diploma graduates already available. Why should you make the B.ed for another qualification?
So, my lord,
Well, experts are
this
available.
notification, my lord, pan India. That's the problem, my lord. This notification is applied pan India. It's not particularly for any states, my lord.
What were the materials before you on the basis of which you?
That notification,
Then you will be in trouble. Do you have any survey done of pan India?
No.
so my lord, there are certain cases, for example, Maharashtra, they have been using services of Sahaya Shiksha Mitra.
Maharashtra, we have 500 vacancies, only 200 are
So,
available.
my lord, for this,
Tamil Nadu, there, have you done something like that?
well, there is a history to it because I'll just give the list of dates.
Have you done such a survey or not? Yes or no?
So, my lords, there are records before the NCTE which says that, and there are several requests which
No,
came
no.
from the
All it refers to is a requisition by Kendriya
Kendriya Vidyalaya.
That is all it does.
Absolutely.
And some request of Uttarakhand.
Yes.
Uttarakhand, my lords, and UP had certain cases, Maharashtra had certain cases.
It doesn't refer
Where
to UP, it doesn't refer to any other.
the notification specifically doesn't, but it was an pan-India issue, my lords, because Rajasthan, apart from Rajasthan, no other state has been, this issue has been faced.
You know, the pan India issue.
My lords, there are other high courts which have even upheld this notification, my lords. The Bihar, then Bombay High Court, then Himachal High Court in Uttar Pradesh.
Are those
They are upholding this notification.
Are there appeals here? No, but,
No, only West Bengal.
Himachal, there is no appeal. Patna has made them eligible, Calcutta and Bombay. So Patna, Calcutta, Bombay, Himachal, both.
Yeah, this case.
Calcutta was interim.
Calcutta just followed the Rajasthan.
Correct, correct.
Yeah,
Correct.
they just followed the Rajasthan.
This was an interim state since the matter is before your lordship said this will be subject to
That
the
interim order is under challenge. There's no final adjudication in Calcutta.
So there are four.
Calcutta only said, Malak, that this will be subject to the special petition in some of the matters, and some of the matters are now before your lawsuits. Only
What
that.
Calcutta said, we'll read the order, not what my friend says it said.
I will.
Calcutta said very clearly, we follow Ram Charan Maurya and they are eligible.
No, not that one. I will be placing that one.
So, all right, fine, you are with them.
Yes, ma'am.
Or they are with you, whatever.
So, my lords, I stand by our notification because that notification is for a particular
You have to,
reason.
yes.
Please, ma'am.
You have a notification, you have to step.
Any, any special clarification from me, I'll submit then in addition what my lord has said.
You give us a 2-page.
Page note.
20 lines in each page, not more.
That's
Now, you,
Union has also filed an SLP. I also want to be explained.
yes,
After the union minutes, I'll add some 4 points minutes which are,
you are on the B.ed side.
I'm on the B.ed side. In the first item, that is minutes 107.
I had certain submission for the policy matter also. Those are the judgment which I would like to cite on because this is again a policy matter for us.
Policy matter, the Ratio is the same.
Please, my lord.
No need of authorities now.
So this qualification, my lord,
Too
is
well
not an
established.
additional or anything. It's an expansion of a zone for that qualification. That's the sum and like short submission I wanted to.
Whatever semantics you use,
Because it doesn't take away the right of B.ed. Like
There you are in such a sticky wicket, you don't even know that. What? See, suppose I am a diploma holder, madam. Suppose if I am a diploma holder, I have done my education training with only one goal in mind, that I want to become a elementary school teacher, right? My education is specific to teacher as an elementary school teacher. I have spent my whole life in that. I have to become a teacher in an elementary school. I am focused in that. Now what happens is, when I am about to get a job, you put somebody else who was not qualified as a primary school teacher. Then, and I am not qualified to get the job which a B.ed candidate is qualified to. As an elementary school teacher having a diploma, I am not qualified to teach in a higher secondary school or a secondary school. But he has been made qualified to teach in school. What about that? Those aspects have not been addressed.
no, my lords, what happens here? It's not that they get diluted. If there is a vacancy, they get a chance. They're also eligible to apply. In addition to that, the B.ed student also can apply, is something the notification says, my lords.
No,
And
it doesn't
that
say
will
in
make it mandatory for them to take that 6 months bridge course. My lord, now considering, as my lord, I understand, the person who takes up
That's
the
what
2 years
I'm getting
diploma
to this.
for primary education.
Don't get into this. If you keep on getting more and more into it, then there will be more and more trouble for you. Because then we will have to open more aspects which have not been opened till now. If you just keep it to 23(1), this maybe, I don't know. But if you say
powers under the enactments, my lord.
then you see there is a whole range of fields which have
I
not
don't
been
want to
touched.
open those arguments, my lord. We stand by the notification
Bus.
and, my lords, the powers which we derive from the statutes to come up with that notification.
That's it. Because otherwise, there will be there are many aspects which have remained untouched.
I bow down.
To some extent, Rajasthan High Court shall be touched. To some extent.
As regards legislative competence of NCT, I have given the provisions to my lords
no
that I
problem.
again don't want to repeat.
yes, madam.
Union has also filed a substantive SLP, that's item 44.1.
What's your
Well, as we've given, we prepared written submissions on also.
grievance?
Well, as the grievance is, my lords, that without making us a party, our decision has been, and without a challenge to our decision has been interfered with. And the finding today is that NCT is not bound by the directions that central government gives to NCT. The NCT derives its power. The NCT is the authority made by a notification of the central government that they are the authority who are going to be deciding this. Well, please see, before your lordships, the merit of the decision is not there. That was neither questioned, nor examined, nor dilated on. There is no finding on the merit of the decision. What is decided by way of the impugned order is that there is no power. And please see, if I can show to your lordships the conclusion.
You can open the field if you want to come to the merit of the decision. No problem.
Well,
because then everything is against you.
Well, my respectful submission is I am in an SLP against an impugned order passed by the High Court. And please see what are the conclusions.
Possibly your only point would be that your decision, your power has been commented upon without making.
Well, it's not just commented upon. If, my lords, the central government, if it is said that NCT is not bound by the directions that central government gives to NCT, that is going to create a plethora of problems. That is going to.
That's the only point you can.
Yes. So, my lords, I want to show to your lordships the final directions that came to pass.
That is being said because in Right to Education Act, there is no such provision. In NCTE Act, there is a provision. Normally, in every act where such an authority is created, there is a provision. That in case there is a confusion, in case there is a date, final say will be that. Even if it is not there, you can still argue on that, but then.
My lords, I am going to borrow the submissions that my learned colleague has made in entirety.
Yes.
on the scope of the two acts also. In our respectful submission also, my lords, there is no dichotomy in these two acts. It is not like the two acts are at variance with one another and they need to be harmonized. The 2009 Act operates on a different plane and the 1993 Act operates on a different plane. It cannot be said that the 1993 Act is at variance with, because otherwise your lordships will see 2009 Act does not prescribe qualification. And my lords, your lordships were putting that that question of appropriate government also. Your lordships will see, my lords, that appropriate government is defined in section 2A in the 2009 Act, and the entire scheme of the Act, it refers to appropriate government. So wherever it wants the appropriate government to have the final call on a particular issue, that is how it is. But section 23 only talks about central government. Would your lordships kindly have section 23 again with me, my lords?
You're absolutely correct.
So section 23 leaves no manner of doubt that it is for appropriate government or who. Section 23, the power is only to be exercised by the academic authority, NCT, authorized by central government. It does not deal with any appropriate government here, my lords. Therefore, that issue may not arise here. My lords, I wanted to show to your lordships, kindly see the conclusions, the final directions that the High Court, my lords, gives in para 49, my lords. That's the summary of the conclusions. And my lords, we are here by way of a permission to file SLP because we were not a party there. We were.
Has the permission been given?
You were a party. Please summarize this.
Yes, your lordships have para 49, my lords. We see the impugned notification of 28 June 2018 is unlawful because, number one, it is under the direction of central government, which power the central government under subsection 1 of section 23 of the RTE Act did not have. And it is not in exercise of power of the central government under subsection 2 of section 23 of the RTE Act, relaxing the eligibility criteria prescribed by NCT, nor there has been any exercise for ascertaining existence of conditions precedent for exercising such powers. The petitioner have no locus to challenge the petitioners have locus to challenge the notification merely because an additional qualification is recognized as one of the eligibility criteria. Petitioners cannot be prevented from challenging it. Now, please see, accepting a candidate with B.ed degree as eligible for appointment and thereafter subjecting him to complete the bridge course within 2 years of appointment is in the nature of relaxing of existing eligibility criteria, which the central government could have done only within subsection 2 of section 23 of the subject. Then the state government could not have ignored the notification of NCT.
Just answer one question.
Yes, madam.
You are saying that you have asked them to have B.ed as an alternative.
Yes.
Right?
Yes.
According to you, B.ed is a full qualification to teach in primary schools?
No, my lords. That is why the bridge course has been prescribed.
Yes. Why? What is the use of the bridge course?
My lords,
which means B.ed is not a qualification.
My lords, I am not getting into that argument that B.ed is sufficient to our mind also. B.ed by itself per se is not sufficient. That is why bridge course is prescribed.
You have deliberately put in a qualification which you know is not a qualification.
In public interest, my lords.
What is the public interest?
My lords, please see our letter itself of my lords 30th May 2018, which letter the NCT Act. There are 4 reasons. I'm sorry, my lords. This letter, my lords, it's reproduced in the impugned order itself. The 30th May 2018.
Yes, 30th May.
Yes, my lords. There are 4 reasons prescribed in the letter itself. If your lordships will see para 2, my lords, and my learned colleague placed before your lordships, my lords, the minutes of the meetings, my lords, some of the other letters, the request, etc. My lords, your lordships put it to NCT. Are they supporting the decision? This is a consultative process that has gone on. And whatever difference of opinion has taken place in the consultative process has been accounted for. But finally, if a decision is taken, my lords, that decision, the central government and the authority which is nominated by the central government, we are, and this is a pan-India, my lords, it has been applied across the country. Rajasthan is the only state that did not follow the NCT notification. So my respectful submission is para 2 itself notes specifically that this is number 1, in order to safeguard the interest of the students. Number 2, the quality of education.
Which paragraph?
That's para 2 I am placing for your lordship's kind consideration. I am just paraphrasing the reasons.
This is in which paragraph of the judgment? This particular letter?
Yes, ma'am. I'll just go. Para 16, I'm grateful to my learned colleague. I actually marked it in the compilation. There was a compilation.
Para 16, the letter.
All right. The above request you're reading? The
above request, I'm grateful, Manoj.
Got it.
Above request has been considered in this ministry in order to safeguard the interest of the students, ensure the quality of the education. The competent authority has decided to agree with the request of KVS to recruit primary teachers with higher qualification. The insufficient number of eligible DLED candidates due to low pass percentage of TET.
See, this is a problem with only KVS.
6 months.
My lords,
Insufficient number of DL, whatever it is called,
yes,
diploma, let's say,
DLED.
are only for KVS. That is a problem.
My lords, that is a problem pan-India, my lords. Our respectful submission is.
Where do you get this idea that it is a pan-India?
My lords, it has been considered in the entire consultative process.
Where?
28th May meeting says similar request has been received from Uttarakhand government also.
Uttarakhand is not,
similar kind of request has been received from.
Uttarakhand would not mean the entire country.
But there are other states also.
Where? There was no material before you to come to that.
My lords, my respectful submission is.
KVS is fine.
My lords, if your lordships wish to see the material on the decision, I'm sure we can.
No.
The whole point we are here before your lordships, my lords, challenging a decision which has not gone into any of this. In fact, it was not before that the Honorable Rajasthan High Court. What was before the Honorable High Court was whether they have power. That's the aspect that has been canvassed. That is the aspect they have looked at, and that is the aspect that they have returned, my lords. So we are, my lords, today challenging the decision on the reasoning that is there in the decision. If your lordships wish to see, my lords, we have also not examined, we have not placed it before your lordships. But if your lordships wish to see the material, we'll place it. In our SLP, we filed application permission.
Point with Mr. Pavalia.
Please, madam.
Let's say that.
My lords, your lordships will take our written submissions. We've just made a 3-page written submission. Grateful, madam.
Kindly give me minutes.
You are
fine.
On policy also, our written submissions are there because
So well said.
policy has not been examined at all. That's our grateful, madam.
Minutes. I'm in the lead matter. The first SLP by the minutes candidates.
by the B.ed.
Who B.ed candidates?
What is the
20743. Devesh Sharma versus.
That is 44 point what?
Let's. I wish to celebrate on certain
No.
Number.
What is the number?
44.0.
item 44 minutes.
What about itself?
You want to make some points in addition to what?
Yes, minutes.
What are those points?
That's my first and foremost point is that the Right to Education Act, which is enacted, has a different objective. Universal education was the focus of that act because the children were not going to schools, etc., etc. Before that, NCT Act had been enacted in 1993 with a specific focus as to what kind of teachers and what kind of teaching is required to be done. National Council of Teachers Education Act operates in a specific field, whereas Right to Education Act in the entire field, universal field. The powers available to the NCTE, which is constituted as an expert body in the field of education, is in a different perspective. it has to act as a regulator, like Medical Council of India for medical education, or Dental Council of India, and let's AICT, etc., etc., etc. In all the acts, including the Medical Council of India Act, in which this Honorable Court in 2010 ruled in MCI versus State of Karnataka that the expert bodies would have independence in functioning for the purpose of quality in the field in which they are regulating the scheme of implementation of the objectives. In my humble submission, when it comes to decide as to what kind of teachers would be eligible to teach, it is the NCTE Act whose objectives would be required to be looked into. Now, learned ASG was referring to that page wherein the objective was being read. I have done some homework. There is a larger objective in which the schemes are happening. For example, straight away, let me convey to your lordships that this diploma in elementary education is going to be stopped.
No, that has come in that.
No, I'm telling larger.
We will stop, then we'll talk about it.
It is
no, we will not. No.
It
said it will be 4 years after 10 years.
I'm connecting the whole policy, how it is evolving.
That is not what the judgment is founded on.
Lordship is right.
Judgment is founded on
in future we are going to have authority.
If your lordship want me to confine only to the judgment.
Only to this.
In the
otherwise there will be problem. If you want to.
No. What I'm reading from the letter of the government itself, it says that it is going to be stopped. That next.
Yes, I've seen that letter.
Yes,
it is going to be 4-year course and all that.
4-year B.ed course.
Yes, if you stretch it, no problem.
No. What I'm saying is that the policy decision which has been evolved and implemented by the NCTE Act is not in the vacuum.
If you are going to stick to what is there, you may have something. But go out of it.
I'm confining. If that was not referred to in the letter, the Honorable High Court has said that there is no application of mind, and this kind of a direction was not binding or could not have been given by the central government to the NCT. My learned friend Mr. Patwalia has pointed out that there were deliberations. What is seen in the letters is outcome of huge number of days devoted.
Which is the new point you are placing. This all has been argued.
I'm placing that point in the context that the decision that has been taken by the NCT to include B.ed qualification as a qualification of eligibility could not be violated by the state of Rajasthan by inserting in the advertisement that B.ed would not be entitled to compete for the certificate.
That the High Court has also said that it couldn't have done it.
No.
Once NCT places a qualification, Rajasthan government is bound by it.
Our petitions have been dismissed and we have been excluded from being considered. That is my evidence.
The judgment. But then the court says that since we have already said that the entire access.
In my humble submission, my petition has been dismissed, upholding that you are not eligible to compete.
Yes. Right.
On the ground, that state of Rajasthan notification doesn't require it.
Yes.
And NCT's notification is without valid.
Without that invalidity of NCT notification, solely on the ground you might not have.
I'm in milits. If NCT notification is allowing me to compete along with the DLED.
So that's what Mr. Patwalia.
That's a big question whether you will be in or out.
Therefore,
right now you are out.
My humble submission is I am out on account of that. Education is a concurrent subject. The notification issued by the NCT is pan-India. The advertisement cannot go beyond what is entitled to me under that act.
Correct.
My point is that only.
Yes. My High Court judgment also says that.
But High Court judgment dismisses my petition.
Because
no, the advertisement has not been quashed.
No. Because that notification was found to be
here.
Therefore,
only one more point is that
you reserve your argument. You can
very well.
First, section 23(1). That NCT comes as a persona designator. Any academic authority, it could have been Indian Institute of Technology, hypothetically I'm saying, it could have been Indian Institute of Management, any academic authority of India could have been a persona designated under Section 23. So NCT is a persona designator. Therefore, the NCT Act of 1993 per se will not apply.
Sorry?
That is why, my lord, the 1993 Act of National Council of NCT Act.
Why will it not apply?
It will not apply because NCT has been picked as a persona designator. But it is a persona designator, my lord.
Maybe persona designator. Then you see the amendment which came in 2012, and 12A was inserted.
Correct, but I come to that.
Which includes that. Then this argument will not stand now.
That argument is that the notification which has been issued is issued by the NCT in its capacity as a persona designator under 23. It has not relied upon minus 12A points about enactment of regulations. It is a notification, not regulation. Very important point, my lords. Persona designator means, my lord, that a person, only that person is entitled. My lord, may I say this? May I elaborate, my lord? May I elaborate this? And my lord, what are the section 35 says?
No, see, we haven't understood this persona designator. What are you arguing?
Well, the point is, my lord, that suppose
persona designator is NCT. Now they have issued the notification.
Correct. So we'll be concerned with RT Act only. Well, suppose in the RT
Act itself, there is reference to other authorities.
Correct. Yes.
Yes.
Suppose I'm just giving hypothetically. I may take some time. Suppose in Indian Institute of Technology. Rather, I'm just hypothetically giving. So the Indian Institute of Technology Act by which is created would not apply for purposes of this act. Academic authority could be any authority in India. It could be, it doesn't say government authority. It could have been even a private body. Now, supposing Ashoka, I was giving an example. One of their very private universities were great things. Academic authority could be anybody. Academic authority is not defined. It's a very important point.
No, because you're arguing it's important.
Yes, my lord. Yes, my lord. It has to be. Nothing will come into your matter. It will be substantiated.
You are saying academic authority, right?
Correct, my lord.
The moment it says authority, it means something of the government. So please correct yourself. It cannot be Ashoka.
Very good, ma'am.
And when this act had come, Ashoka University was not even in existence.
Well, I'm not saying
so something like something like that.
IIT, Indian Institute of Technology.
Yes.
Indian Institute of Management. All these are government authority, government act or something like that. So if the academic authority is brought into the fore, the prescribed qualifications, then that authority is bound by this act only. It is acting independently. It cannot rely upon the act from which it is created. That is the point. Therefore, the concept of NCT Act coming into
and there is no reference to NCT Act.
Nothing. It could have been any academic authority. Therefore, my lord, our point is that NCT Act would not apply for construing the notification which has been issued under Section 23(1). The notification itself says 23(1). If it had been 12A, my lord, 12A says about regulations, and NCT has issued regulations 2014. Under 12A is not there, my lord. So these are all not letters, they are not executive instructions, they are quasi-legislative. Notification is quasi-legislative. Kindly see 12A now, my lord.
Well, I'm sorry to interrupt. I think your lordship should look at page 189. That is the notification by the central government authorizing NCT to be the designated authority under RTA.
No, he is arguing that.
That's what he's saying. He's also saying
supporting it. Well, the point which I am making is, my lord, kindly see the that act of NCT, my lord. Really, it says regulations to be framed. So there are no regulations which are framed in this case. So 12 is not attractive. But the point was, read 12 into it. Mr. Patwalia's entire thrust was, please read 12. He was not shying away from section 23.1. He was saying, please read 12.
So please read. Now, instead of this, notification, which is under challenge, which is ostensibly under 23.1.
No, but it is written as 23.
What is written?
It is not ostensibly, with due respect, it's written as 23. Yes, ma'am.
Now, suppose had it come by way of a regulation, then you would have no problem.
Then one of the decision, even the arguments would have been on different foot. Correct?
Sorry?
Then the arguments would have been on a different footing altogether. At present, the argument is that 23.1 powers has been exercised on the dictate of the central government. Doctrine of dictation.
See.
Manoj, may I say this? The law is that if a particular power can be seen on other ground, even if it is not mentioned, it can be seen into it fearlessly. But those are about executive powers. These are quasi-legislative powers. You are defined by the four corners of the statute. It is not a collector may say, I have passed under the Revenue Act, it may be under the Excise Act. It is not that order. This is a quasi-legislative act.
No, under 23.1, they can pass a notification.
They have passed it.
Yes. So in any case, the NCT has got powers.
They have powers to frame regulations under 12A. Yes, ma'am.
Under 12A by regulation,
Correct.
But under 23A by notification.
Correct, ma'am.
So in any case, they have powers. NCT has powers.
Correct, Manoj.
Correct, no?
Manoj, we are only in this present case, we are on the manner of exercise of power. We are not the source of power.
I am not coming up to the manner. Forget manner.
Correct.
NCT has got power to prescribe qualification under 23.1. Right? It is what it has done under 23.1. There is a problem.
The problem is it is an academic body having an independent, autonomous mind of its own. An academic.
What makes you?
Not read 35.
What makes you think that it has not applied its independent mind?
That's your submission. Can it the NCT, SLP itself says that on directions of central government we have done it. I'll read to the NCT before my lords.
We will show it tomorrow, the letter of the minister and then NCT's.
We have seen all that, madam.
Kindly see section 35, madam. Kindly see 35 of this act.
Which one?
Of the RTA. My lord, we will be only concerned with the RTA. We will not be concerned with the NCT. That's our submission, madam.
According to you, there is no authority defined.
No academic authority is defined on that.
Defined.
Correct, madam.
There is a vacuum.
No. It has been defined now by the central government as NCT.
Yeah.
The NCTs comes as a, that is why we do respect, came with the word personal designator. It is a defined authority under the Act. It cannot rely upon the parent Act to draw its power. Its powers would be circumscribed by the RT Act. It cannot draw power from any other act in even in the act which has created it. That is our submission.
So you are on that by incorporation and reference principle.
I am on the point that it is an authority, it is an academic authority. 35 now. Can you see 35?
Import what they have in.
Right, section 35. Let me make it clear.
Yeah,
35 of the RT Act. It is not the central government cannot issue guidelines. Central government has the power under the RT Act. It has power to issue to the appropriate government or the local authority. It has no power to issue directions to the academic authority.
Argument is akin to somebody on deputation in some.
The point is that you have entrusted NCT as an academic authority to determine the standards. You cannot get
once NCT enters this act,
correct,
then they get bound by
within this act.
And not borrow its power or authority from
applied. And that would explain. And section 35 says local authority and appropriate government. It doesn't say academic authority. That's the point. My lord, make
Take
tomorrow
it
meeting
tomorrow.
10:30.
Not 10:30, after the miscellaneous matters. It will be the first matter among the regular.